Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can you go to jail at a pretrial conference? It's a question many people facing legal issues ask, and it's a valid concern. A pretrial conference sounds formal, but is it a place where you could suddenly lose your freedom? In most cases, the answer is generally no. You typically will not go to jail directly from a pretrial conference. A pretrial conference is usually a meeting between the judge, the prosecutor, and your defense attorney. Sometimes, you, the defendant, might be present, but often your lawyer handles most of the discussion. The main goals of these conferences are to discuss the case, explore potential plea bargains, set trial dates, exchange information, known as discovery, and try to resolve the case without needing a full trial. It's a procedural step, not usually a sentencing hearing or an arrest event. However, there are some very specific and rare exceptions where you could find yourself in custody. Let's look at a few of these situations. First, if there's an outstanding arrest warrant for you that was issued before the conference and simply wasn't served yet, the court might discover it. This is uncommon if you've already been appearing in court, but it's a possibility if it's your very first appearance or if a new warrant was issued for an unrelated matter. Second, if you have a separate case and failed to appear for a court date on that other case, a judge might have issued a bench warrant for your arrest. If this warrant is active and discovered during your pretrial conference for the current case, you could be taken into custody. Third, a significant reason could be a violation of your bail or bond conditions. If you were released on bail, you agreed to certain rules. If the judge learns during the conference that you violated one of these conditions, for example, failing a mandatory drug test, contacting a victim you were ordered to stay away from, or leaving the state without permission, your bond could be revoked. If your bond is revoked, you would be immediately taken into custody. Fourth, if you commit a brand new criminal offense while out on bail for the current case, and the judge is informed of this new charge, they might decide to revoke your bail, leading to your arrest. Fifth, though very rare at a pretrial conference, if you act disrespectfully or disruptively in court, the judge could hold you in contempt of court. Depending on the severity, this could result in immediate detention, though this is highly unusual for a defendant who typically has a limited speaking role at such a conference. Finally, in very specific situations, a plea agreement might be reached at the conference that includes immediate jail time, usually for minor offenses or very short sentences. But typically, if jail time is part of a plea, sentencing is scheduled for a later date. So, while it's not the norm, these exceptions show why it's always critical to have an experienced attorney by your side who can advise you on your specific situation and help you navigate the legal process. They can foresee potential issues and protect your rights. Thank you for watching this video. If you found this information helpful, please give it a thumbs up and consider subscribing to our channel for more legal insights. We appreciate your support.